Good afternoon, everybody, and welcome to the latest instalment of Lewis Silkin's IP360 series of webinars. My name is Nick Bowie. I'm a legal director at Lewis Silkin's brand and IP team, and I specialise in online brand enforcement, routinely handling large-scale online enforcement projects and cross-jurisdictional litigation arising from trademark and copyright infringement on the internet. I'm also joined by Anna Caruso, an associate in our brands and IP group who specialises in brand development, protection and enforcement. She advises on a broad range of contentious and non-contentious intellectual property matters across a diverse range of industry sectors, with a particular focus on the tech sector. Anna's also one of our ambassadors for Cube, Lewis Silkin's bespoke startup offering. Finally, we're joined by Neil Parks, a partner in Lewis Silkin's litigation and IP teams. Neil has many years of experience in online rights protection acting for broadcasters, film studios, sports rights owners, games companies and luxury brands. He's been involved in several leading cases concerning the enforcement of IP rights online, including website blocking orders and private criminal prosecutions. In today's webinar, we will provide a high-level outline of the key drivers that inform an effective online enforcement strategy, legal strategies employed and practical considerations. While online enforcement will form part of a broader strategy that may incorporate, for example, tech solutions and supply chain considerations, this webinar will focus on the legal aspects of online content and brand enforcement. We're delighted to see so many familiar faces, so many familiar names in attendance, and equally we're delighted to welcome some new ones. The level of online enforcement expertise among our attendees varies from those with limited experience to those with general commercial law backgrounds through to experts in the fields of online brand enforcement and anti-piracy. On this basis, the webinar is pitched somewhere in the middle. So before we get underway, a couple of housekeeping points regarding WebEx. Those of our attendees logged in through laptops or computers will be presented with several windows. You can either minimize or switch between those windows by clicking on the minimize icon at the top right of the relevant window. Attendees' microphones have been muted. If you have any questions over the course of this presentation, please feel free to submit them via the chat tool provided, ensuring they're directed to host, presenter, and panelists, and we'll do our best to address them at the end of the webinar. So without further ado, I'll pass over to Neil to discuss the key drivers that inform an effective strategy. Neil.
And hello and welcome everyone. As Nick said, it's great to be joined by you all today. I'm just sorry we're not quite ready to have everyone in the same room and be able to have a more interactive discussion of this topic and obviously miss out on the post-event wine and canapes, but hopefully we can do that again soon. In the meantime, as Nick said, do use the chat function to submit any questions or comments or to share experiences on this issue, and we'll try and pick some of those up at the end if we've got time. So whether looking at one-off infringements or ongoing issues, it's important to have a strategy to tackle the problem. So let's start by looking at what a strategy is and then look at some of the key things that need to be considered in developing a strategy for the enforcement of IP online. This definition I took from an online dictionary is probably a good starting point in terms of remembering what a strategy is. It being a plan or action designed to achieve an overall aim. But before we get to the plan of action and before we even get to the aim, I suggest starting by identifying the problem. And that's not always going to be the same, and it's not always going to be so obvious. I mean, in some cases, the most obvious problem is likely to be online counterfeits or infringing copies of media content, domain abuse, etc. But it's also necessary to consider why that's a problem. And again, that might seem obvious, but in many cases it is lost sales opportunities. In others, for example, in the field of luxury goods, it might be more likely that tackling cheap copies is more about protecting the brand reputation and exclusivity rather than direct lost sales. Or in some cases, it might even be consumer protection, which of course can turn into brand reputation. Another example may be more inadvertent infringements. So, for example, users who are exceeding license terms or the number of licensed users of software or services online. And that's very likely will require a different and more subtle approach than tackling commercial online pirates, where, of course, in the case of the online services, you're going to want to try and convert those to paid customers and get them more in line with their license terms. Or it may even be a one-off infringement issue that you're dealing with, which is large enough to require a strategic approach. So having identified the problem, let's look at what the aim is. And again, that might seem obvious. We want to stop the problem, but it's never quite that simple, particularly when you bear in mind some of the other bullet points on the slide about being realistic and being able to measure whether the aims have been achieved. The aim will also very much depend on obviously the problem and whether it's possible to fix that problem, or whether you're just looking to disrupt and use the disruption to educate others, whether that's infringers or consumers, or to set a legal precedent establishing liability so that that can be used to put pressure on or to help intermediaries to improve their processes and procedures in response to takedown requests, for example. A good example of that is the sale of Kodi streaming boxes online for sale on online marketplace and social media platforms, which were pretty prevalent before a CJA ruling and some criminal convictions in the UK, which described what was also resolved what was described as a grey area by the media. I'll pick that up again later. It's important to also be realistic, I mean, particularly when dealing with stakeholders who may not fully appreciate that often the infringement of IP rights online is not normally something that can simply be stopped, as I just said. So, although it can be, significantly disrupted and reduced, and really the aim being to turn this activity for the infringers from a low-risk, high-reward activity into a high-risk activity. And again, that's going to depend very much on the problem that's been identified. One-off infringements are going to be considerably easier to stop, hopefully, whereas a pandemic of infringements are only probably going to be capable of being slowed and disrupted. And measuring your success. I mean, as with any strategy implementation, it's going to be necessary to think about how you're going to measure the success or the achievement of the targeted aim. Increased legitimate sales or subscriptions could be one way, but that's so difficult to track and link to the enforcement action. So, even in disruptive strategies, there can usually be a way of measuring the success of that strategy. And one way we're doing that at the moment with a number of clients is by tracking and reporting on response rates from target website operators and the number of takedowns, the number of domain names that have been transferred, and useful intelligence that's been obtained from targets about other infringements and so on. And that's obviously much easier to track and measure than increased sales or subscriptions, which, of course, the marketing department would probably claim credit for anyway. Budget is probably the next thing to consider. I mean, is your strategy driven by the budget, or is the budget the result of the strategy? In many cases, there might not be a defined online enforcement or anti-piracy budget at all. It's necessary, therefore, to think about a strategy that may, to some extent, be able to fund itself. Whether seeking financial settlements from those that can pay so as to cover the legal costs of a campaign. If there's little or no budget at all, you may be left with limited strategic options, but steps can still be taken. So we can still reach out to law enforcement and work with strategic partners. PIPQ, Police Intellectual Property Crime Unit, being a good example of that, and the Intellectual Property Office, some trading standards, etc. There isn't one solution. Obviously, I mean, it's unlikely in the context of online enforcement that one size will fit all, and not one action will get you to your aim. So we need to think about online enforcement in terms of a toolbox of tools that do different things in different circumstances. Some are going to be blunt instruments, think police kicking doors in. Others are going to require a bit more skill to use properly, we'll look at some of those later in terms of online blocking orders, for example. But the point is that your aims might be more easily achieved by using multiple tools in a harmonious way rather than simply deploying one tool. Impact is the next point, by which I mean it's important to understand the ecosystem of the infringers. There'll be different layers and levels of players involved, so think about what impact action at each of those levels is going to have and how easy that is going to be to achieve. So for example, it might be easy to identify low-level sellers who need to and do advertise and promote their wares on social media or via search engines. But what impact is that going to have on the overall problem? And of course, this may also be driven to some extent by the budget, your ability to identify those involved at the higher levels and where they're based, whether they're in the jurisdiction or not. But even disruption at the lower level can still have an impact, especially if it's used and communicated correctly, and can sometimes lead you to, higher up the chain, can sometimes lead you to information about those running systems and producing the goods higher up the chain. And finally on this was, do you go it alone or do you team up? And some of the best examples I've seen of online enforcement successes and those I've been involved with come from industry bodies working on behalf of a cohort of rights holders or through cooperation between interested stakeholders. Good examples of this are the work done by ACE, the Alliance for Creativity and Entertainment, on behalf of the global membership of media businesses. And in terms of cooperation between stakeholders, the work the Premier League do with broadcast partners and licensees across the globe, including Sky here in the UK. So having outlined that, I think now I'm going to pass over to Anna, who's going to look at the important role of monitoring and investigations and how we can sometimes use legal tools to help further those difficult investigations. Anna.
Thanks, Neil, and good afternoon, everyone. Welcome. So as Neil rightly highlighted at the very beginning of this webinar, one of the key questions we need to ask ourselves when deciding what enforcement strategy to adopt is, what is the issue? What is our problem? In fact, it's impossible to tackle a problem if we don't know what that problem is in the first place. So this is where the importance of proactive monitoring comes into play. There's a vast range of online and offline technical tools that can, assist right holders in tackling online infringement. And again, there isn't a one-size-fits-all solution, but even in your monitoring, the tools need to be tailored to the type of industry you're operating in, the type of rights you're trying to protect, and again, always bearing in mind what your end goal, what is it that you want to achieve. So for example, monitoring counterfeits on eBay will require a different technical tool than, say, monitoring infringing trademark applications or infringing content on social media. But no matter the underlying intellectual property rights we're trying to protect here, it is extremely important to have appropriate monitoring systems in place, as this allows you not only to identify, the issue, but also catch them at an early stage. And this, very often it can turn out to be more cost and time efficient in the long run. But assuming, we do have monitoring systems, we do know what our problem is, the next question that immediately arises is, who is carrying out the infringing activities? And I think we're all very much conscious and aware that one of the biggest problems on online enforcement is, identifying the wrongdoer, who often hides behind anonymity offered by the internet. In an ideal world, we would take someone to court, get the proof of infringement, get a relief, and move on. But unfortunately, isn't that straightforward when you don't know who your infringer is, you don't know where they're located, and you may not realize the full extent of infringement. And so identifying the wrongdoer is closely tied to other key issues that may arise, such as where are they located and do we have jurisdiction to operate? So there are clearly a lot of hurdles, but it doesn't mean we're powerless. Again, there are a lot of online tools at our disposal. which can assist to some extent in identifying infringers. And many of these tools are freely accessible online. So think of, for example, WHOIS records or historic domain records, the web archive, even things such as online profiles, usernames, email addresses, which all can give away a lot of information, or social media posts and IP addresses. So there are many tools that can give us information, and often this information is sufficient, but very often it can only lead us that far. And this is where additional legal tools can come into play. And a particularly powerful tool, which we thought was worth mentioning in this webinar, are the so-called Norwich Pharmacal orders. And many of you may be familiar with this type of order, but just to give you a very brief definition, this is essentially it's a court order which is granted for the disclosure of documents or information, which is issued against third parties which somehow have been mixed up, whether innocently or not, in a wrongdoing. So it can be particularly helpful to obtain information when it's relating to wrongdoers that is held by third-party operators. So, a classic example of this is where you need information of online profile operating off of Facebook or, some other social media platform. And this can be a very powerful tool, and it is becoming more common. And particularly in England and Wales, it is important to remember that the jurisprudence has evolved a lot, and it's really broadened the scope of, for example, the type of intermediaries that you can issue the order against, and even the types of infringement and the scope of the order following that. So, and this isn't the case, for example, in other countries. So we think, for example, Ireland, where these type of orders are still quite narrow. There are obviously costs that would come with, using such a legal tool, and normally the applicant would have to cover legal costs, for providing reasonable disclosure. But generally, these costs we find, in our experience, they are quite modest because, for example, the platforms or other third parties such as banks will be used to these type of orders and have sort of fixed fees in place, or while they might not outright consent to the order, they might not oppose it, which again would bring down costs. There are obviously a number of legal requirements to obtain such an order, and you may already be familiar with these. I won't go into any detail in these now because they could have their own separate seminar, but we just included them here in this slide for your reference. I know you've worked a lot with these type of orders. Is there anything you maybe wanted to add in terms of practical considerations or top tips when considering to adopt one of these?
Sure, thanks, Helen. I mean, probably my top tip in terms of practical considerations with Norwich Pharmacals is early engagement with the intended respondent, the third party that holds the information that you seek. I mean, sometimes through that, fairly rare occasions, it has to be said, but it can be possible to obtain the cooperation and get the information you need without the need for a court order at all, whether directly or through use of information sharing arrangements that some of those intermediaries have in place with industry bodies or the Intellectual Property Office or even PIPQ, for example. So even if no such swift route exists to get the information and an order is required, it's still important to have an open dialogue at an early stage with the holder of the information. And one of the things first things you want to ensure is that they have or should have the information that you require. I mean, sometimes they'll be able, indeed willing, to confirm whether or not what they hold appears to be valid information, or whether it on the face of it might be false names and addresses, for example, in which case you might save the time and costs of a dead-end application. Many intermediaries also receive a sufficient volume of these types of requests. I mean, Anna mentioned banks, for example, ISPs. So they have a policy regarding how they will deal with those, how they will respond. They might have their own preferred form of draft order even. They'll often have a particular legal entity that they would prefer applications to be made against. We then need to look at whether that entity is within the jurisdiction, and whether there's sufficient grounds to serve any applications out the jurisdiction if they're not. And also try and identify what conditions or undertakings the intermediary might require, and whether they are going to consent to the order if you meet those conditions and give those undertakings, or whether they will not consent but not oppose to the order, which is actually the most common response, or whether they're even going to oppose the application for some reason. And obviously it would be helpful to understand what that reason is before you get too far down the road. And finally, as Anna said, there's obligation to pay costs of compliance with these orders. So, seek details early on of what the respondent expects those to be, whether they've got fixed costs of dealing with these types of things, or otherwise what they anticipate them to be, whether they're intending to instruct outside solicitors, for example, and incur those types of costs, etc. So, try and avoid any nasty surprises, ultimately. And having gone through that early engagement and dialogue, I guess, the application process and then compliance with the order should, in my experience, go much smoother. So, Nick, I think you're going to pick up now on some of the direct legal enforcement options that are available.
Yeah, thanks, Neil. So, once we've identified infringements of our brand or content online, and even better, identified and located the wrongdoer, what next? So to a large degree, the next steps are governed by the aims determined by the business and the ways in which success is measured, which should be tweaked according to the nature of the acts being targeted and the information identified during monitoring and investigation stages. So identifying a wrongdoer in their location opens up a range of options, traditionally starting with a cease and desist letter. Not only a cease and desist a pre-action conduct requirement if your business is considering litigation, but they can act as a vehicle to achieve many of the business's predetermined aims, whether they're to convert infringers or wrongdoers into sales leads, or to educate infringers or wrongdoers through knock and talk visits at the infringer's place of business or location linked to the illicit acts. Whatever the aim of the letter, you must consider the tone carefully. A heavy-handed cease and desist letter designed to educate consumers may result in negative PR for the business, while conversely, a letter designed to deter wrongdoers that lacks any weight may not elicit the desired change in behaviour. Now, as most of us know, traditionally cease and desist letters are served through posts, but you can up the ante by using legal process servers to serve letters in person. We work with many clients to conduct knock and talk visits, and in some cases our lawyers will attend a doorstep service of a cease and desist to engage with the wrongdoer and discuss the content of the letter, not only to explore the possibility of resolution, but ultimately to educate them. Now, Neil, you handle a lot of work for clients that have incorporated knock and talks into their enforcement strategies. Do you have any further comments in that regard?
Yeah, sure. So I think the first thing to say is that, and apologies if everyone else is getting that echo, I'll start again. So yeah, I think the first thing to say is that that we've seen a really great, real success from engaging in knock and talk procedures, whether that's using process servers just to sort of make the importance of the letter more obvious to the recipient, or whether it's even deploying some of our lawyers onto the doorstep, usually flanked by an investigator for sort of risk assessment purposes, and so that they can possibly gather more intelligence while they're there. I think the key thing is that we're just getting much greater levels of engagement in response to those letters delivered in that way. The purpose is not to, you need to be careful about it, the purpose is not to stand on the doorstep and, put people under pressure or threaten them with legal action, etc. Although that's obviously fairly clear from the content of the letter when they get to it. But it's to help them understand what's being said. It's to help them understand what we're asking for in terms of compliance. And we're very careful about making sure, it's important in these situations to be very careful about making sure you comply with professional obligations and not taking advantage of litigants in person on their doorstep and so on. So, with those caveats in mind, they can be a very, very useful tool. And as I say, we found that, in recent months when we've been using them, we've had to slightly adapt procedures over the last 18 months for obvious reasons. Sending people out onto doorsteps not been such a good idea. But we've certainly found that those types of approaches, where you can identify someone in the UK, have proven to be very effective, and we've got clients now deploying similar tactics in other jurisdictions across the globe. Back to you, Nick.
Thanks, Neil. So moving on to education of consumers. If your online enforcement strategy seeks to educate consumers, it's important to consider the positioning of the message and the medium through which the messaging is communicated. We find that often these messages are amplified best if a business engages with their PR and comms teams to ensure that message is amplified in the right way. Do you wish to relay positive messages or guidance as to how consumers should avoid engaging with wrongdoers, for example, or should the messaging be more forceful, serving as a warning to wrongdoers, perhaps supported with evidence of recent enforcement successes, including litigation? Consider how best to amplify the messaging. For example, if your successes have received press attention, consider how best to use it for the business's aims. So in circumstances indicating a large-scale problem and where litigation may only address a small proportion of the issue, perhaps a disruptive strategy is preferable, designed to persuade wrongdoers to move on and use their talents in other ways, possibly even targeting competing brands. So a double win. If so, consider whether to engage in a program of takedown or suspension notices, whether that be hosting services, e-commerce platform takedowns, payment processes and the like, and targeted domain name recovery. Additionally, it may be worth considering whether a combination of online brand enforcement and litigation, namely to seek injunctions and other interim remedies, would cast a wider net over the problem. Litigation is probably your area of expertise here, Neil, so I'll pass over to you.
Of course. So yeah, litigation obviously can play a very important role in any online enforcement strategy. I mean, sometimes it would be one of the main routes to seek to prevent further infringement or redress for infringements, particularly where you're able to identify the infringers and they're within jurisdictional reach. It's also important that any cease and desist activity, whether threatening letters, knock and talks, polite letters, etc., as we've discussed, is backed up with action in the event of non-compliance. So you need to, be prepared to follow up with litigation. What you don't want is you don't want to become known as having a bark worse than your bite. Imagine a situation where online forums, for example, are full of infringers who are boasting to others that they've received letters and they've ignored them and you've gone away. You don't want to be, one of those brands who has that reputation of, well, ignore them and eventually go away. And obviously litigation such as a High Court claim or claim in the IPEC can, in appropriate cases, lead to a finding of liability, usually a permanent injunction preventing future infringements, and award of legal costs and ultimately damages, whether you fix those and claim them up front or whether on an assessment. But it's litigation could also helpfully act to set a precedent, as Nick said earlier, in relation to new types of infringements, the new use of new or emerging technology, and can be useful in support of future enforcement action or to provide legal clarity or certainty. successful claim can also have a deterrent effect as regards other infringers and help change perceptions. And I'll look at some of those, some examples of that in a minute. First, it's also worth mentioning that although the costs of such measures mean that they're usually only reserved for the most egregious offenders, the courts do have really powerful tools that can be deployed in appropriate cases. So, for example, search and seizure orders or Anton pillars for the older members of the audience like me. Freezing injunctions, freezing assets in bank accounts, online payment providers, even, crypto wallets, or immediate interim injunctions without notice, obviously destruction orders and the like. And not forgetting the ability to enforce financial judgments if you get one. So using the various litigation tools that are available in terms of enforcement. I've had the pleasure of being involved in at least these 2 separate cases, which have ultimately led to court-appointed bailiffs taking possession of supercars from infringers who benefited quite significantly from their actions. That's quite satisfying, I can tell you, but although neither of them ended up on my drive, unfortunately. Then we've got criminal litigation. So I talked earlier about enforcement, engagement with law enforcement agencies, whether that's specialist police units like PIPQ or local constabularies, trading standards, even some regional financial crime units. They have very powerful tools at their disposal in terms of investigations, obtaining search warrants, making arrests, conducting interviews, etc. And clearly a criminal conviction and a stiff sentence against an infringer can have a significant deterrent effect. It's all about, say, turning that dial from low risk and high reward to high risk and low reward. Engagement with law enforcement can obviously bring significant benefits and results with low costs, particularly if you're dealing with publicly funded agencies. However, there's obviously a lack of control over an investigation carried out by law enforcement, and often little or no interaction with the public prosecutors, CPS, where they consider you or your brand to be the victim. And there's also, the issue of available resourcing to support such sort of public investigations and prosecutions. And that does lead some rights holders to consider the use of the right that we have here in the UK to bring a private criminal prosecution. And whilst this is not straightforward, requires specialist knowledge and definitely needs to be handled with care, given the duties that are imposed on a prosecutor, higher burdens of proof, etc. In the most serious cases, it can be a very effective tool. And if anybody's interested in that, I do have, having done both civil and criminal litigation in this field, I've created a bit of a comparative guide to the differences between criminal and civil litigation. So I'd be more than happy to supply that to anyone who was interested. And whilst I'm also in the chair, I just want to say a little bit more about making good use of the media as something that we, both Nick and I think touched on earlier, and the important role that media can play in an online enforcement strategy, depending, of course, on what the aim is. And I picked this selection of headlines just because there are cases I was involved with. I mean, they just mostly relate to online film, TV, and music piracy, but a quick Google search will likely also lead to similar types of reports concerning other types of infringements, such as counterfeit goods and the like. But these cases illustrate how carefully chosen litigation, and these are both civil and criminal actions here, there's a mixture of them, including some private criminal prosecutions, can be designed to educate or disrupt and have an impact beyond just the targets of the action. Clearly, the individuals involved in each of these cases ceased their infringing activities, and they were either punished for it by the criminal courts or they paid for it through the civil courts. But these headlines obviously will also go some significant way, I would say, to educating the public who might be consuming content that these types of infringers provide. And obviously you can use litigation to change perceptions. So working with communications and PR teams, whether you are a size of organisation who have such internally or whether using external agents, that working with those can help to change public perceptions through the media again. And that might be one of the aims of the enforcement strategy. So here again, using TV piracy as the example, you can see how even the way this issue of what are called Cody boxes was being covered by some media in the early days of their popularity. So these boxes were media streaming devices, but they were being sold fully loaded with the ability to access infringing content online. Effectively, they didn't have the content in them, but they had all the signposts in them and links. And this was being, as a result, described as a legal grey area. That's not very helpful when consumers are being offered access to thousands of TV channels and a library of films via a box you can buy on the high street for a one-off fee of £69, for example. See here, Brian Tomo Thompson outside his cut-price TV shop on Teesside, brazenly advertising, free TV via these boxes. And then look at the contrast a few months later, after a CJEU ruling and a criminal case that was brought here in the UK against poor old Tomo. And this helped hugely in getting further and quicker engagement from intermediaries whose platforms were being used to sell these types of devices, where the platforms themselves were not necessarily fully appreciative of the infringing nature of these devices, given the way the media were describing them as in a legal grey area. As a result, the open listing of the sale of these types of devices on intermediary platforms as significantly reduced as a result of that type of change in perceptions. And talking about intermediary platforms, Nick's now going to look at the role of intermediaries and what the role they can play in an enforcement strategy.
Thanks, Neil. Well, as an aside, if anyone recognises the news headlines displayed previously, it could be for one of two reasons. Either you keep a close eye on IP in the news, or because if you look above Neil's right shoulder, he's got a collage of them framed above it. So anyway, now we'll shine a spotlight on intermediaries. So collaboration is key to an effective online strategy, particularly those incorporating disruptive tactics. Without the assistance of intermediaries who, once notified, have an obligation to ensure their users comply with relevant law, it's particularly difficult to make a material impact on wrongdoers' illicit conduct. What assistance you require from the intermediary will depend largely on the nature of what you're trying to obtain. For example, do you seek suspension of infringing content on a website, in which case you might consider posting takedown notices, or in instances of widespread infringement, engaging with ISPs to block internet traffic, which we'll come on to in a little bit. Alternatively, does the wrongdoer facilitate orders and payments through its site, in which case you might consider abuse complaints with payment processors or order facilitation APIs such as Spotify, WooCommerce, and the like. Are counterfeit goods offered for sale on e-commerce sites? If so, consider registering the business's IP rights on the e-commerce platforms in question and issue takedown notices against counterfeit or infringing listings. Many e-commerce platforms are incorporating machine learning in their brand protection efforts to the extent that after a few waves of takedown notices, the platforms actively monitor and suspend suspicious listings before they're displayed publicly. Over to Anna.
Thank you, Nick. So just with the focus still on intermediaries, it is important to also mention, I think, that some operators will actively work with brand owners and issue infringement proceedings, in case of the most egregious infringement. So if you think of, for example, the recent 2020 case involving Amazon issuing proceedings against, I think it was 2 influencers who promoted and facilitated the sale of counterfeit goods on the platform. So in respect of its third-party operator, it is important, as Nick was saying, to create and nurture those relationships, and it will harness, better level of cooperation and not least because, they may hold information that can unblock the case. So we find, like, on a daily basis, it is very important to have this relationship because it can go a long way. And broadly speaking, I think we could, there's 3 categories of intermediaries. On the one hand, there's those operators who are cooperative, who have, a clear and sophisticated procedures, and want to assist right holders, and they're also generally very, very responsive. So this would be actors, such as Amazon, eBay, Facebook, Twitter, Google, YouTube, and so on. And they will offer, an online complaint system, and it can often be just, fast and a very cost-efficient route to achieve, for example, the deactivation of infringing content. But then on the opposite spectrum, we have those operators who instead are used as a safe harbor by wrongdoers. And this could be because of the jurisdiction they're based in, or because that particular jurisdiction has a less developed case law. And in this case, you'll find that they will ignore your takedown request. And in this case, there is little point in trying to increase cooperation. However, there is a third category that sits in between, and these are operators who are keen in principle to assist, but might be nervous of breaching their user rights by cooperating. So, for example, maybe by breaching confidentiality obligations or breaching data privacy laws. And in these instances, they often won't take any action unless it's actually in compliance with the official court order. And again, this is where specific legal tools can play a key role. Perhaps the ultimate weapon in our arsenal is blocking injunctions, which can be a very powerful tool in these sorts of scenarios. So a blocking order is in essence an order for internet service providers, but also other intermediaries such as maybe search engineers, operators, to block their users from accessing particular websites or content. And England is one of perhaps the most proactive jurisdictions for blocking orders, particularly following the Katir case, which some of you may be familiar with, which extended blocking orders against service providers beyond copyright, which was already sort of a statutory provision. And so these blocking orders can be very effective. And as I said, in England, they're very wide in terms of availability and scope of the order. If we were to compare this, for example, in the US, first of all, there isn't any equivalent statutory powers, and the case law is definitely much more limited. And in England, these orders have evolved in time, also to adapt to the nature of online infringement. So, for example, we have dynamic blocking injunctions, which are meant to cover instances where there are repeated infringements. So, for example, there's cases where you take down a website and then a materially same website immediately becomes available after you've, on a different IP address. And so these type of orders can factor that without having to go seek another order for the new website. There are also live blocking orders, which allow the repeated blocking on a site every time, for example, a live broadcast is in process. So these orders can really be tailored to the industry you work in and what you require. And we are very happy to have Neil today on this webinar with us, because he's been involved in order both in copyright and in the case where it was granted to website selling counterfeit goods. Perhaps do you want to add any comments about the potential use of blocking orders and how we can use this as a tool in our toolbox?
Yeah, sure. Thanks, Anna. I think you've covered all of the main points there, but I think for me it's about the potential flexibility of these types of orders, as you mentioned, both in terms of the types of IP rights and infringements that they can be deployed to help protect. They've now been used in the UK in respect of content like films, TV, music, computer games, and the distribution of ROM codes that can be used to play counterfeit versions of computer games. There was a case by Nintendo, and the sale of counterfeit and luxury goods. And you mentioned the Cartier case. So, you know, and there's no reason why that couldn't be extended further. The flexibility of the jurisprudence and the discretion that the English courts have in respect of these types of orders, albeit subject to certain checks and balances and requirements. But also, as you mentioned, how they can be, you know, updated. They can be dynamic and live orders, and the ability to report essentially the same website or essentially the same infringing service when it moves domains or moves IP address, for example, without having to go back to court. And that's made the use of these types of orders much more effective and less costly, I guess, because you know you don't need to keep going back to court to amend the order. And indeed, as you mentioned, Anna, you know, in some cases the orders are flexible enough to allow for blocking of even as yet unidentified infringements, but which are identified in the lead up to or during, for example, a live broadcast of a sporting event, which meets certain criteria laid down by the court in the order. You know, and these orders can be in place to cover not only one-off live events in the future, but also, you know, such as a premier boxing bout, but even an entire sort of season or tournament. So, you know, think of the dynamic live Premier League blocking orders and UEFA blocking orders. Again, though, it's one of the tools in the toolbox. You know, it's not always going to be the most appropriate, and it's going to be something that you might want to deploy alongside other things. You know, they can be circumvented by determined users, and they can therefore have limited impact in some cases. But I think these types of blocking orders can play an important part in an overall strategy. You know, one of the actions in the plan targeting the ultimate aim. Nick, do you want to just sort of, conscious of time, wrap up and do the summary, and we'll take a quick look, see if anyone's got any questions. If anyone does have any questions, I guess now's probably your last chance to pop them in the chat. Any questions or comments, and we'll pick them up in a minute.
Thanks, Neil. So to conclude, I mean, it's crucial to have a strategy, and to a large degree that is determined by the problems a right holder faces, the nature of those, the ultimate aims of the right holder, and it's key to be realistic as to what is achievable. It's crucial that that strategy is routinely reviewed. I mean, bad actors can adopt and adapt to new technologies much quicker than legitimate businesses and lawmakers. This means that one of the key challenges is keeping on top of new technologies. Just one example of this is on our radar at the moment is the development of non-fungible tokens and the selling platforms. Now, NFTs is a topic that we shouldn't really go into any detail now, and actually one of our colleagues, Cliff Fluett, has given a presentation on NFTs previously, and if that's of any interest to anyone, then please get in touch and we'll arrange for a copy to be sent to you. But also, with more and more businesses moving into this space, we're conscious of the opportunities, but also of the hidden risks, with counterfeiters and scammers targeting platforms and right holders. So the main issue with new technologies is that enforcement and monitoring tools may not cover these new platforms yet. New actors often don't have established takedown protocols, and there is a general lack of awareness, which leaves businesses particularly exposed. So I am conscious that we are pretty close to the end of our time slot. So, oh, hold on, we've got one question come in, and Neil is probably a good person to answer this. Aren't private criminal prosecutions very expensive?
Thanks for that, Nick. Yeah, so there can be. I think it depends. Like anything, I think it depends on the nature of the infringement, the nature of the evidence that you have. So some of the private prosecutions I've dealt with, some of them have been pretty modest, and the cost of pursuing them has been less than the equivalent civil litigation, because with the assistance, the rights holder we were working with on that particular one had the assistance of the police, for example. The police were able to utilize their powers of search and seizure effectively, search warrants, as a result of which we had the type of evidence you can only dream of in a civil case, which is, you had access to the entire hard drive of the infringer. And so when you put the case together, and if you do it in the right way up front, you can very clearly establish that they're guilty, and you serve that on the defence, and they can very quickly plead guilty. So in those circumstances, they can be proceedings that are over and done with pretty quickly, and therefore cheaply. Obviously, other cases where you might incur, defendants who are going to defend the claim and plead not guilty and need to go to trial, they can be quite significant. Although, again, I think it's something to be borne in mind, because in addition to it being a very powerful tool, it can actually become quite cost effective. And the reason I say that, and there are some limits to this, but in essence, as a private criminal prosecutor, you are acting in the name of and on behalf of the Crown or in the public effectively, even though you are representing the victim. And as a result of that, there's legislation in the UK that provides for private prosecutors to recover their costs from either the defendant, if they're able to pay them, and if not, you can actually seek an order that they are paid from what we call central funds or from the Treasury. So in effect, the public purse can reimburse you for some or all of those costs. They're subject to assessment, and those costs are assessed by public cost assessors. So yes, I think the answer to the question is, can be very expensive, but so can civil litigation. But there are routes to recover those costs, either from the defendant or even from the public purse.
Thanks, Neil. So we've got one last question. What is the best way in your experience of dealing with individuals or entities who use copycat websites or email addresses posing as a client for fraudulent or phishing purposes, where a UDRP is not available? So I can probably have a go at that one. It depends to a large degree whether it's a one-off. If it's a one-off scenario, then you could apply to the hosting company that provides domain name that provides hosting services to that domain name in question, to have all of the domain names, all of the DNS records shut down, which would result in suspension of that domain name until it expires. The challenge that you'll face is that there is nothing to stop the domain name owner just moving the hosting services to another domain name. So in those types of situations, it's worth setting up monitoring services, because a good monitoring and investigation service underpins any effective online enforcement strategy. So I think we have come to the end of our time slot. So I'd like to take the opportunity to thank everyone for coming. I think that's the second slide with our faces on it, which is very self-indulgent. But thank everyone for coming. Thank Neil and Anna, and take the opportunity to invite you all to our next IP360 webinar, which is on the 26th of October, and it's an introduction to brand clearance featuring ad slogans. Thanks very much for listening. And if any of you have further questions, please feel free to direct them to Neil, Anna and I, at the email addresses provided. Thanks for your time. On that note, the lights have gone out.